The petitioner plays a critical part in initiating and supporting the visa application on behalf of the beneficiary. Let's look at some of their key duties and tasks. Pledge to USCIS. The petitioner's main responsibility is to confirm to USCIS under oath that the information provided in the petition is accurate, to the best of their knowledge. This commitment is a key aspect of the process. Signing the visa petition. The petitioner must sign the visa petition, along with a statement acknowledging potential costs of the beneficiary's return transportation if the visa ends prematurely. This is a formal acceptance of responsibility in case of early termination. Providing company information. Part of the petition process involves the petitioner supplying essential company details, such as contact information, employee count, length in business, and tax identification number. This data gives a complete picture of the petitioner. If you opt for an agent as the petitioner, you'll be required to furnish an agent agreement contract, along with details regarding the events, roles, and employments that will be facilitated through the agent. Adhering to deadlines. To prevent delays and ensure a smooth process, the petitioner should respect timelines. Submitting Form I-129 at least 45 days before the expected employment start date improves the chances of a successful O-1 visa application. As you can see, there are quite a few things that your petitioner will have to cover. Please remember that it is in your best interests to make sure all of it is covered. In the end, this is your future at stake. One of the questions that often concern people is, are there any financial risks for the petitioner? When thinking about the petitioner's role in the O-1 visa application, addressing potential financial concerns is essential. It's important to emphasize that being a petitioner doesn't impose any extra financial responsibilities or liabilities beyond those stated in the petition and related documents. This means that being a petitioner doesn't mean you're liable for the beneficiary's personal expenses or any other costs not explicitly mentioned within the petition or related agreements. For instance, the petitioner is usually expected to cover the filing fee for Form Y-129, the petition for non-immigrant worker. However, responsibilities can significantly differ based on the specific agreement between petitioner and beneficiary. It's always advisable to review all documentation carefully before submitting the application. Forms. The petitioner, whether a U.S. employer, a U.S. agent, or a foreign employer through a U.S. agent, files Form I-129, Petition for Non-Immigrant Worker. This petition, with the necessary supporting evidence as mentioned in the form instructions, is key to securing O-1 visa approval. Advisory opinion. The petitioner must supply a written advisory opinion from a peer group, labor organization, or an individual with expertise in the beneficiary's field. It is a professional validation of the applicant's abilities and achievements that strengthens the application for O-1 visa approval. The advisory opinion is important because it showcases the applicant's exceptional credentials and abilities, strengthening their case for visa approval. It forms an integral part of the required documentation for the visa application process. Contract between petitioner and beneficiary. For O-1 visa applications, the petitioner should provide the employment contract or a written summary of the verbal agreement between the employer and the employee. This document outlines job responsibilities, payment structure, and other relevant factors, showcasing the validity of the employment. Whether it's a written contract or a summary of a verbal agreement, ensure this is part of your documentation. Itinerary. For O-1 visa applications, it's necessary to provide an itinerary of planned U.S. activities. This document gives a clear picture of the professional engagements and commitments during the O-1 visa period and should cover work details, position, duties, work hours, and employer information. It's important to plan carefully, avoiding overlaps or conflicts, particularly if dealing with multiple employers. Remember, in Dreem, our visa hub, We will be happy to provide information and support you with consultations, with filling out the forms and templates for the job offer, advisory opinion, and itinerary to assist you in your application. If you are pursuing your application with an agent petitioner, you will need to include in your application an agent agreement. Additionally, you'll be asked to provide an itinerary detailing all your upcoming work engagements and, most importantly, work contracts or letters of intent of the roles you will be engaging in. It's important to note that the agreement with the agent beneficiary and the itinerary should not be considered as substitutes for individual contracts, job offer letters, or deal memos from non-petitioning employers. These specific documents must provide comprehensive details about each event, such as employment terms and performance expectations. This ensures a thorough representation and helps prevent the possibility of a request for evidence or denial, especially if the adjudicating officer perceives the employment as merely speculative. That's the end of the lesson. The summary quickly. Pledging to USCIS, signing the visa petition, providing company information, adhering to deadlines are the main responsibilities of the petitioner. Forms, advisory opinion, contract between petitioner and beneficiary, itinerary are the main docs to provide.